Hello everyone, welcome back to my YouTube channel Legal World. Myself Dr. Seema Goyal. As in the series of banking law, I have discussed many important questions relating to the banking law. Today I am going to start with the Negotiable Instrument Act. And in this series, I will discuss with the first important question relating to the Negotiable Instrument Act. That is, define the negotiable instrument and also define the fundamental characteristics of the negotiable instrument. Or it may be asked in the another form, what do you understand by the negotiable instruments? Also discuss the legal presumptions of the negotiable instrument. Or define the negotiable instrument, also state the basic characteristics which distinguishes the negotiable instrument from the ordinary goods. If we talk about the meaning and definition of the negotiable instrument, that is known as विनिमय साध्य विलेख. विनिमय साध्य विलेख का शाब्दिक अर्थ ऐसे लिखित सलेख से है जो किसी व्यक्ति के हित में अधिकार उत्पन्न करता है और जो सुपुर्दगी द्वारा हस्तांतरित होता है. भारतीय विनिमय साध्य विलेख अधिनियम में विनिमय साध्य विलेख की कोई अलग से परिभाषा नहीं दी गई है. उसमें केवल यही वर्णित किया गया है कि विनिमय साध्य विलेख में कौन कौन से विलेख सम्मिलित हैं. भारतीय विनिमय साध्य विलेख अधिनियम की धारा कोज 1 के अनुसार विनिमय साध्य विलेख से आशय किसी प्रतिज्ञा पत्र, विपत्र या चेक से है जिसका भुगतान आदेशित व्यक्ति या वाहक को दे होता है. अतः यह संकुचित परिभाषा है क्योंकि इसमें प्रतिज्ञा पत्र, विनिमय पत्र तथा चेक के अतिरिक्त अन्य विनिमय साध्य विलेख नहीं आते. ये परिभाषा विनिमय साध्य विलेख के स्वभाव एवं विशेषताओं पर कोई प्रकाश नहीं डालती. अकॉर्डिंग टू केसी विलेस, विनिमय साध्य विलेख वो संपत्ति है जो सद्भाव से तथा मूल्य के प्रतिफल से प्राप्त करने वाले व्यक्ति को उन दोषों से मुक्त रखती है जो हस्तांतरणकर्ता के स्वामित्व में है. If we talk about the characteristics of the Negotiable Instrument Act, first characteristics of the Negotiable Instrument Act that distinguishes the negotiable instrument from the ordinary goods. First characteristic is हस्तांतरणशीलता, मीन्स ट्रांसफरेबिलिटी. विनिमय साध्य विलेख का स्वामित्व एक व्यक्ति से दूसरे व्यक्ति को ट्रांसफर किया जा सकता है. हस्तांतरण कार्य स्पुर्दगी द्वारा या आदेश पत्र पर देय विलेख होने पर स्पुर्दगी एवं बेचान द्वारा किया जा सकता है. सेकेंड वन इज लिखित में होना. इट मस्ट बी इन रिटर्न. मीन्स विनिमय साध्य विलेख लिखित में होना चाहिए. लोक मौखिक विनिमय साध्य विलेख मान्य नहीं होता. थर्ड वन इज हस्तांतरी का सर्वश्रेष्ठ अधिकार. यथाधिकारी के स्वामित्व पर हस्तांतरण करने वाले दोषपूर्ण व्यक्ति का कोई प्रभाव नहीं पड़ता. यथाविधिकारी के स्वामित्व पर हस्तांतरण करने वाले दोषपूर्ण स्वामित्व का कोई प्रभाव नहीं पड़ता. यदि यथा विधिधारी ने सद्भावना के साथ, गुड फेथ के साथ मूल्य के बदले विनिमय साध्य विलेख को प्राप्त किया है तो वह उसका स्वार्थी स्वामी हो जाता है, भले ही हस्तांतरण करने वाले का अधिकार दोषपूर्ण क्यों ना हो. नेक्स्ट, निश्चित धनराशि का भुगतान, मीन्स अमाउंट मस्ट बी सर्टेन. विनिमय साध्य विलेख निश्चित धनराशि भुगतान करने की लिखित प्रतिज्ञा या आज्ञा रूप में होना चाहिए. इसके अंदर जो राशि दी जाती है वो निश्चित राशि होनी अनिवार्य है. एंड द नेक्स्ट कैरेक्टरिस्टिक इज वाद प्रस्तुत करने का अधिकार. यथाविधिधारी स्वयं अपने नाम से वाद प्रस्तुत करता है एवं हस्तांतरण करते समय वो इसकी सूचना स्वीकर्ता को देने को बाध्य नहीं है. एंड द नेक्स्ट कैरेक्टरिस्टिक इज विनिमय साध्यता. विलेख में विनिमय साध्यता का गुण होना अनिवार्य है. एंड द लास्ट कैरेक्टरिस्टिक इज प्रतिफल का वर्णन अनिवार्य नहीं है. विनिमय साध्य विलेख में प्रतिफल होना स्वभावतः निहित होता है. इसका विलेख में स्पष्ट होना अनिवार्य नहीं है. इफ वी टॉक अबाउट द लीगल प्रिजम्पशंस ऑफ ए नेगोशिएबल इंस्ट्रूमेंट, विनिमय साध्य विलेख की वैधानिक मान्यताओं की यदि हम बात करते हैं तो ये कुछ मान्यताओं पर आधारित होता है. जैसे कि नंबर 1, प्रत्येक विनिमय साध्य विलेख प्रतिफल के बदले ही लिखा गया, स्वीकार किया गया तथा बेचान द्वारा हस्तांतरित किया गया हो. सेकेंड इज प्रत्येक विलेख पर लिखित तिथि वही हो जिस दिन वो विलेख लिखा गया हो. थर्ड वन इज विलेख की स्वीकृति लिखने के बाद परंतु देय तिथि से पूर्व हुई है. नेक्स्ट वन इज विलेख का प्रत्येक हस्तांतरण उसके परिपक्वता से पहले किया गया है एवं प्रत्येक बेचान का क्रम वही है जो विलेख देखने से पता लगता है. कंडीशन इज विलेख उचित प्रकार से तथा नियमानुसार मुद्रांकित किया गया है. एंड द लास्ट कंडीशन इज विलेख का धारक यथाविधिकारी है. तो दीज आर द सर्टेन लीगल प्रिजम्पशंस ऑफ द नेगोशिएबल इंस्ट्रूमेंट दैट इज कंसीडर्ड. If we talk about the definition of negotiable instrument is a written and unsigned unconditional promise or order to pay a certain specified sum of money on demand or at a definite time payable to order or bearer. The Negotiable Instrument Act 1881 does not define the term negotiable instrument but merely states that a negotiable instrument means a promissory note, bill of exchange, or the check payable either to order or to bearer. As per Section 13 of the Negotiable Instrument Act does not indicate the characteristics of the negotiable instrument but only states that three instruments, that is check, bill of exchange, and the promissory note, these are the negotiable instruments. Thus, there are the negotiable instruments by the statute as per Section 13 of the Negotiable Instrument Act. But it does not prohibit any other instruments that may also be coming under the category of negotiable instruments, which bears the essential features of the negotiability to be treated as the negotiable instrument. If we talk about the kinds of the negotiable instrument, there are generally two types of negotiable instrument. First is negotiable instrument by statute. Second one is negotiable instrument by custom or the usage. If we talk about the negotiable instrument that is defined by the statute, that is Section 13 of the Negotiable Instrument Act 1881 that states the three types of instruments as the negotiable instrument. That is promissory note, bill of exchange, and the check. As the negotiable instrument of three kinds as per the statutes. But if we talk about the negotiable instrument by custom or the usage, according to Section 137 of the Transfer of Property Act, instrument may be negotiated by the custom and their negotiability will be considered a negotiable instrument and they are recognized by the courts also. The instruments falling under the category of hundage, bank draft, bank notes, dividend, warrant, interest warrant, postal order, railway receipt, they are also coming under the category of negotiable instruments by the custom. And that have been recognized by the court also. It is overwhelming to point out that the negotiable instrument does not stipulate that only the promissory note, bill of exchange, or the check are the negotiable instrument. Thus, the other instrument may also be considered under the category of negotiable instrument. But it must fulfill the certain conditions. First condition is they are transferable by means of delivery or by the endorsement and the delivery both. Second condition is holder in due course can sue in his own name. These are the certain conditions that must fulfill in order to call it negotiable instrument. If we talk about the essential features of the negotiable instrument, as per Negotiable Instrument Act, there are the certain characteristics. That is first, title to it passes by delivery. Second condition is holder for the time being may sue in his own name. Third condition is notice of assignment need not be given to person liable thereon. Next one is bona fide holder for value takes free from any defect in title of predecessors. And the last feature is instrument is of type recognized by the law as negotiable. For example, bills of exchange, promissory notes, and the checks, dividend warrant, debentures payable to bearer. These are coming under the category of negotiable instrument as they are fulfilling these features also. Thus, it may be concluded that the instrument is called the negotiable instrument as it possesses the certain characteristics. That is transferability. Means it is transferable by delivery or by endorsement and delivery both. Second condition मैंने जैसे बताई आपको, holder's title must be free from defects. The holder in due course acquires a good title, notwithstanding any defect in the former holder title. A holder in due course is one who receives the instrument for value and without any notice as to the defect in title of the transferor. And the third condition, that is holder can sue in his own name, as I have told. Another characteristic or the feature of the negotiable instrument, that is the holder in due course can sue in his own name. That is essential. And the next condition, that is endorsement. There is no restriction on the number of endorsements of the negotiable instrument. Any number of the endorsement can be done, can be made till the maturity. It can be transferred by any number of times. And the next condition is unconditional. Means negotiable instrument must contain an unconditional undertaking. It is wrong to say that I will pay after a day from the marriage of my son, or on the ground that the maturity of the payment of the instrument will be uncertain. This means to be called a negotiable instrument, there must be unconditional undertaking. That is must. And the next condition, that is payable in money and certain sum of money must be there. Means amount must be certain. that is described under the negotiable instrument. Means negotiable instrument must be payable in the form of money only, and the amount must also be certain. It must not be uncertain. And the last is certain presumptions is also considered. A negotiable instrument is subject to certain presumptions. That is presumed under section 118 of the Negotiable Instrument Act. It describes the certain presumptions regarding the negotiable instrument. First is consideration. Every negotiable instrument shall be presumed to have been made or drawn for consideration. Means consideration is essential. Second presumption, that is regarding the date. Every negotiable instrument bearing a date is presumed to have been made or drawn on such date. Third presumption, that is regarding the time of acceptance. Every acceptance of the bill of exchange is presumed to have accepted within a reasonable time after its date and before its maturity. And the next presumption, that is time of transfer. The transfer of the negotiable instrument is taken to have been made before its maturity. Next presumption, that is order of endorsement. The endorsement appearing upon a negotiable instrument are presumed to have been made in order in which they appear thereon. And the next presumption regarding the stamp. It is presumed that a lost promissory note or the bill of exchange or the check was duly stamped. And the next presumption, that is regarding the holder in due course. Means it is presumed that holder of a negotiable instrument is a holder in due course. However, where the instrument have been received from any lawful owner or from any person in lawful custody thereof by means of any offence or fraud, or has been received from any maker or acceptor thereof by means of offence or fraud or for unlawful consideration, the burden of proving that the holder is a holder in due course lies upon him. As per section 119 of the Negotiable Instrument Act, this presumption has been given. And the last presumption, that is regarding the dishonor. Means it is when there is dishonor in a suit upon the instrument, which has been dishonored, the court shall own the proof of the protest, presume the fact of dishonor, unless and until fact is disproved. This means we can conclude that the certain instruments are not coming under the category of negotiable instruments. First is bill of lading and the railway receipt. These are transferable but don't have the better title. This means these are only quasi-negotiable instruments. Second is LIC policy. It is not freely transferable by the endorsement and the delivery. So it can't be assigned. It can't be considered as the negotiable instrument. And the third one is share certificate. It can be transferred only through a separate transfer deed, and also the defect in title gets conveyed on transfer, and it is not a negotiable instrument. And the next one is postal order. It is not a negotiable instrument as the defect in the title gets passed on the transfer. Debenture. These are also long certificates and are transferable, generally like shares. Therefore, they are not coming under the category of negotiable instruments. Airways bill. It is also received and does not fulfill the characteristics of the negotiable instrument. That is why we can't call this instrument as the negotiable instrument. So this was all about the negotiable instrument as well as its characteristics, and what instruments are not coming under the category of negotiable instruments. If you have any doubt, you must put down in the comment section. And don't forget to like, share and subscribe this channel for the further update. Thank you.